will do that. I will do that.
And Hannah, you're going to jump off?
Yes, I'm going to hide my video. We got, all right, 33 people are slowly popping in.
Okay.
Hey, Karen, what's up?
The sky.
What's down?
The ground.
What's in the middle?
Me.
Cool, we'll take it.
Yeah. So Hannah will let us know when she's starting this.
Fantastic.
It's starting. We have 40 people in here right now. So just going to give it a few minutes, let everyone trickle in.
Okay, so you'll let us know when you're starting though?
Yeah.
Okay, thanks.
Let's give it just one more minute. So
Okay.
I'll holler when we're starting.
Thank you. So Corey, I'll just do a quick introduction and welcome, and then we'll get into it.
Perfect. I'm so excited.
Great.
I'm so excited.
All right, let's go ahead and get started, guys.
Okay. Hello, and welcome to this Massage Magazine webinar featuring Conscious Counsel Legal Services Company. I'm Karen Menahan, editor of Massage Magazine, and today's presenter is Corey Sterling, a self-described heart-leading business lawyer and the founder of both Yoga Law and Conscious Counsel. The scope of Corey's legal practice includes working with massage businesses, and Corey and his team at Conscious Counsel have collaborated with Massage Magazine on creating specialized content, advice, and client intake forms for the massage therapy field. In this webinar, Corey will discuss best legal practices for reopening your massage practice as we emerge from COVID-19, including discussing new laws and regulations pertaining to such health protocols as vaccines, waivers of liability, service agreements, and more. Welcome, Corey.
Thank you so much for having me. It's like, it's always a party when we do this.
Oh yeah. Yeah, so a lot of massage therapists are really wondering about the legal documents they have to have in place, you know, in this age of COVID as we move through it. Yeah, so do you want to kick it off with talking about that?
I suppose that's why I'm here, to chat about that. So the first thing I'll say, hi, welcome everybody. I'm going to change my view. The gallery view, I don't get to see all the participants even. Which is too bad. So hi, nice to see everyone. I hope you're having a wonderful day. The first thing that we're going to start out with, we've had a lot of success with sharing legal essentials for massage professionals. So Jake, I believe that you're on. Jake, maybe you can just throw that link into the chat. And so everyone, as you're watching this, feel free to go into the chat and download this checklist. As Karen mentioned, a lot of massage professionals are curious how to navigate this environment with so many things that are changing quickly. And the checklist is a really good way. It's sort of like a map of orientation for you to know exactly where you are. So that's a free gift from us that we're happy to help with. Secondly, and this is really, really important, and Karen, you might have to follow this as well. If anyone has a snack, if you're eating a snack right now, or you've prepared a snack as you participate in this webinar, let us know in the chat what it is that your snack is. Karen, water does not count as a snack. You're awesome. We know the sky is up. We know the ground is down. We know that you're in the middle, but we're looking for good snack game from everyone. So go ahead and throw it in. For me, this is my yerba mate, my green tea. Whenever I'm chatting about the law and massage professionals, I like to drink it. So I'm going to put that in there. And the whole idea is that I obviously, part of starting a law firm called Conscious Counsel and working with Karen. and working with massage professionals is making it fun. So for me, I know that that whenever I have a snack or a delicious beverage, water included, when that's nearby for me, I'm just in a better mood and I'm more excited to learn about things. So the other thing that I'd like to say is that we do have an hour on the books, and now it's 55 minutes because I've spent so much time talking about snacks. But a really important thing for me, and Karen, I know you're going to help out with this, is that I'm going to talk about different types of agreements that we see our clients needing more and more help with. And when you have a question, please raise it. Please let us know what the question is. Maybe you could put it in the Q&A channel of Zoom. And the reason why is because this is your opportunity. Part of the reason why we love working with Massage Magazine is I love giving the opportunity to give real advice to real professionals who may be needing that. So the sort of the loot bag of what you're walking away with following our discussion today is going to be, you know, the ability to ask questions and a free legal checklist as well, which we've already provided. So that being said, the first thing that I'm going to talk about, and this isn't really necessarily a legal document per se, but I just want, it's always the elephant in the room. And now every webinar or talk that I'm doing, everybody wants to know about protocols, right? So the protocols are changing. How are things, you know, it seems like every week there's a new rule from the government about what we're allowed to do, who has to wear a mask, who's been vaccinated, who not, any of those things. And this is really the one message that I just want to start off by saying to everyone is the importance of following the protocols. And the next thing I'm going to talk about is waivers of liability, and I'll explain why they're more important now than they ever have been. But the reason why it's important to follow the protocols is that in the event that something happens, God forbid, this is real, I'm on a wood table here, it's a real piece of wood, I just knocked on it, but in the event that something happens and it can be shown that part of the circumstance of whatever thing happened was there's a connection to you not having followed the latest round of the protocols, that's a very, very easy legal argument, right? It's very easy for someone to say, oh, well, I contracted this, or I suffered this injury, or whatever it is that happened. And, you know, at the time that you were offering your services, you know, the local municipality or the local government or the state government had a rule in place that said, you know, everyone still has to wear a mask, or only non-vaccinated people have to wear, whatever the rule is. And if you don't follow the rules, that's the easiest legal access for someone to have a strong argument against you. So that's like, to me, that's sort of like the elephant in the room. And I often get so many questions about following protocols. And the answer is a pretty simple one, where it's like, just do your best to stay abreast of whatever the ongoing changing rules are. And so long as you can show that, so long as you have great legal documents and that you're able to show that you're following the relevant rules, that's like the first fortress, the first wall of protection against you. And it's sort of logical and just intuitive that obviously we should be following rules, and whether or not you agree with the rules is one thing, and whether or not I agree with the rules is another thing. But you just have to understand, to explain to everyone who's listening a little bit, the practicalities of how law works. It's not about you going into court and you hiring a lawyer and, you know, a really intense, dramatic cross-examination. That's not really what any of this is about. The way that it happens is that someone suffers some form of damages through the massage services that you're providing to them. And what they're going to say is that you are responsible for the damages that they suffered, because you were responsible to make sure that they would be okay and participating in activities with you. And if they can show right off the bat that, hey, you know, the government said the rules were ABC, but the way that you acted was more like DEF, therefore you are responsible, it already puts you at a disadvantage. And when I talk to clients about the importance of having legal documents and why you need them in place, all of it is for the following reason. Someone is going to file a complaint against you, or they're going to hire a lawyer to threaten you that they're going to sue you, or they're going to email you directly telling you how injured they are, how hurt they are, and how you need to pay for that. The first step always is going to be your response. So someone's going to complain, they're going to send you a complaint. Then the first thing that you're going to do is respond to whatever it is that they're saying. Your ability to establish your legal position assertively in that response is probably the most important part of the duration of whatever this legal battle is going to be. Because one of two things are going to happen. One thing is that you're going to work with, you'll have worked with a lawyer who drafts your documents professionally and tailors them to your specific needs and what it is that you need, what your business needed. And you're going to be able to respond immediately by saying, hey, sorry, you signed this waiver, or this is what our service agreement looks like, and you agreed to this legal relationship before we started working together. Therefore, you do not have a cause of action. When you're able to respond in that manner, you take all the momentum away from anyone who's making a complaint against you. Conversely, if someone's making a complaint against you for whatever reasons, and you borrow your documents from someone else, or you downloaded them from the internet, or you think that they're good enough and you drafted them on your own. And like I love clients who piece together their own agreements, but a massage professional putting together a legal agreement is sort of like me giving someone a massage, which anyways, probably wouldn't be that great, and certainly wouldn't achieve, I haven't gone through the technical and professional training, but when your response to that complaint is, your legal document doesn't address the issue, it's not specific to your business, then not only have you not slowed the momentum of the complainant down, but conversely, they now have more momentum. And then they're going to see, oh, well, this person didn't, their waiver didn't cover them for this, or it wasn't drafted properly, or the service agreement didn't address this. And so when you're in that position, instead of the issue being able to be resolved quickly and taken care of right off the bat, you find yourself behind the 8 ball, you find yourself in a reactive position, and then you're scrambling to try to, then the odds are automatically against you, and we're fighting an uphill battle. And I share all of this with love, and I share all of this from the point of this webinar is practical experience, practical legal advice that you can apply in your experience as being a massage professional. And the foundational piece is having documents in place. And I always explain to clients, it's like, you're not going to court. It's the chances of you going to court are, minuscule. They're tiny. That's not the reality of how the system works. But the chances of you getting involved in a legal dispute, which start with a demand letter, and then based on your response to that demand letter, the course of it will depend on how strong your documents are and how easily you can assert a strong legal position. That's probable. That's really where the rubber hits the road, or as the old massage saying goes, where the hand hits the shoulder blade. So I just want to share all of that, and so far in this introduction, I've talked a little bit about the importance of following protocols, because in the spirit of everything I'm sharing about, I want the people who I work with and the communities that I, share information with to be in the best position as possible. Not following those protocols off the bat already puts you in a disadvantage. And sometimes it's not fun to have to follow these rules, especially because they're changing so often and there can be some ambiguity around them. But it's a really important thing to do. And obviously, as a lawyer, the thing that I would say to you is, have great legal agreements and follow the rules. So I'll pause for a moment to see if anybody has any questions on that. And if not, I can just dive right into waivers of liability.
Hey, we did have a question come in from Merjam, wondering what to do if the massage therapist or the client has a medical exemption to one of the rules or protocols that's in place. If someone can't wear a mask, for example, can they still practice massage therapy, or should they have something written in place regarding that?
I would say the best course of action in the event that you are unable to, for some reason, if you're unable to follow what the protocols or the rules are, I would definitely put it in writing beforehand. And like, this is the whole thing about law that I want everyone who's listening, I want your approach to looking at and interacting with the law to be as follows. It's all about communicating expectations openly and honestly. That's really what the purpose of these documents are, is to protect you, but also so that you avoid the situation where someone would come back at you afterwards and say, oh, like, I didn't know that. You never told me that you didn't, that you had this exemption, or that you couldn't wear a mask, or whatever, insert whatever it is. And it always comes down to that phase that I'm talking about of the legal dispute when things are starting. It's always based on reasonableness. And like, reasonableness, I feel like it's not an overly legal word, so I'm confident, using it. But basically what it means, it's like, how average was your behavior? The way that you behaved, is that how a reasonable professional would have behaved? So when I hear that question come in, if you know beforehand that either you or a client is unable to follow a protocol, that's cool. But like, I would put it in writing to say, hey, we understand the current protocols mandate ABC, but for the following reasons, we are unable to comply with part C of the protocols, and that you understand that before working with us. And what that does is it limits the negligence. You've communicated, and that in the event someone's going to want to come back at you afterwards, you're going to be able to say to them like, hey, I get that you're upset that this happened, but we did tell you before that we weren't able to follow all of the protocols for whatever reason, and you still did sign an agreement saying that you understood that before working with us. And now, just like circling back to reasonableness, like, that seems pretty reasonable. Like, you were aware of the issue, you communicated, and you got someone to sign a legal agreement around it. So I hope that helps answer your question.
I'm wondering if it would be helpful too to kind of delineate the differences between the intake form, the waiver of liability, and the service agreement.
Definitely. Yeah, that's great. Thank you for that prompt, Karen. Okay, so the differences would be as follows. A service agreement is a legally binding document. A waiver of liability is a legally binding document. An intake form is not a legally binding document. Typically, an intake form will be the place where you're going to ask about previous medical history, or you're going to ask about any injuries or other personal information that you need to assess the person that you're working with in order to provide the best services possible for them. A waiver of liability is so in that being said, the one thing that I'll say about intake forms is that usually for massage professionals, it's really good to review your intake form with an insurance provider, because it may be that your insurance has particular requirements that you may or may not have associated to the intake form. But basically, the intake form is an opportunity for you to learn more about the people that you're working with, what their medical history is, if they've had any injuries, if they have any sensitivities. All of that information will be included on the intake form so that you can provide professional services, and everyone who's listening knows how to do this. A waiver of liability is totally different. And a waiver of liability is a document where someone is signing away their legal right to sue you based on the service that you provide to them. So the waiver, and I'm going to dig into waivers now, but just remember this: waivers are different because it's someone signing away, relinquishing, giving up their legal right to sue you based on the services that you provide them. And then a service agreement is the contract or the agreement that you have with your clients. So the service agreement is an example of two people deciding to work together. There's a service provider, there's a client. And as I previously mentioned, the point is to communicate the expectations openly and honestly with your clients, to say, hey, this is the working relationship that we have, and this is how things are going to work. And in the event of scenario A, this is how I'm going to act. In the event of scenario B, this is what's going to happen. And just think of it as sort of communicating the rules and the boundaries of the relationship, which is a really, really important thing to do. And when I talk about service agreements, I'll sort of dive into that. So I'll sort of go into waivers of liability and explain them a little bit more in depth, and why they're so important now. And the first thing that I'm going to say about waivers of liability is that, again, waivers are different because people are signing away their legal rights. So most of the other things that I talk about, or the other types of agreements that we work with at Conscious Counsel, are agreements of two people agreeing to work together. So there's a general principle at law which says that two parties can agree to anything so long as it is not illegal. And what that means is, like, the government's not going to interfere in the private relationships of how massage professionals want to offer their services, so long as you're not contradicting any laws by engaging in that relationship. So it's two parties agreeing to something. A waiver of liability or a release of liability is different, again, because this is someone signing away their legal rights. So the way that it works is, let's say we have no waiver and no agreement is signed, there's nothing. What the law says is anyone who provides a service to another person has a responsibility to make sure that the person who's providing the service, in this case, massage professionals, will make sure that whoever they're working with will not suffer damages or not get hurt in the providing of those services. So you have a responsibility at law the moment that you start working with someone to make sure that that person is going to be safe in your care. And at law, that's called a duty of care. So at law, automatically the relationship is established where you are responsible. However, the law also says, okay, well, we understand that brings a lot of risk to people, so we will let participants sign a waiver of liability, which says, cool, even though normally you would be responsible, because I've signed this document that's properly drafted, and I'll talk about what makes a properly drafted agreement in a second, but because I've signed this agreement, which is properly drafted and specific and tailored to my business, I relinquish my rights to sue you. So even though I would have had a right to sue you, by signing this document, I'm relinquishing that right. I'm giving up my right to hold you legally responsible for anything that happens to me. The reason why this document is so important is because you never know when things go wrong unexpectedly, which is how it works. You never know what the extent of damages are going to be. You don't know what type of damages someone is going to suffer. You don't know how long those damages will endure. And as such, when you go into it, you're not sure about what your extent of liability is going to be. And that's why it's so important to get this one right. This is like the foundational document to protect you and your assets. What sort of drives me crazy as a lawyer is I'll speak to people who've been working on their business for years and put in so many hours and do such great work and want to do it so well. But what they don't realize is, like, when they borrow a friend's waiver or download a template of a waiver that's not specific for them or the current environment that we're operating in, you run a risk of losing everything. And, like, sort of when I say that, it registers. And I think the reason why the waiver is so important is because it protects all of your assets. Conversely, when you look at something like a service agreement, let's say hypothetically, I've got my massage business and I'm doing massages and I've got a client who pays, $85 for an hour, and I've sold them a 10-pack for $850, which is awesome. Now, in the event that, let's say, something happens, that person is very frustrated, very sad, very disappointed, whatever, I was late, whatever happened, I went to the wrong location, whatever it is, that the extent of the damages that you're going to owe if that relationship goes sour is going to be $850. But with the waiver of liability, you don't know what it's going to be for the damages suffered. And that's just to sort of keep the perspective about the importance really of getting it correct. So what needs to be included in a waiver of liability, and how does COVID play into this? Firstly, one question I always get asked is, how often do I need to change my waiver of liability? Let's say I'm doing massage, but I'm also doing hot stones and I'm doing energy healing and Reiki and whatever it is. The rule for waivers of liability is that it will cover you so long as the document accurately describes the types of activities that you offer and the way that you offer those activities. And the reason why is because there's 5 elements to a waiver, and I'm going to walk you through those 5 elements in just a moment. But the first one always is, what are the activities that I offer? If you've got a pen and paper, this is a great opportunity to write this down. What are the activities that I offer, and how am I offering these activities? So why COVID is different and why protocols are different is because the way that we're offering our services have changed, partially because the environment has changed. So it may be possible that you're doing some work online. It may be possible that you're now going into people's homes where before you had a public space. It may be possible that you're doing different things, or you're requiring people to behave in a certain way, like you're mandating vaccines or something like that, whatever it is. You need a waiver of liability to accurately cover the specifics of what you're doing, how you're doing it, and the way that you're doing it. And again, the reason why is, remember, someone's signing away their legal rights here. So in the event that they're going to dispute that and say, no, actually, I was never told, about this, or I didn't think COVID was a real risk for, returning to hands-on massage or whatever it is. You want that waiver of liability in the event that someone suffers some damages. You want to be able to just copy and paste the document and say, no, actually, we told you about COVID, or we told you about contact tracing, or we told you about, doing it in your home or offering services outdoors, whatever it is, you want the document to capture all of that. So preemptively answering the question, how often do I need to change my agreement? Your agreement is good so long as the environment in which you offer the services are the same, the types of services are the same, and the way that you're providing those services are. So all of that being said, the big thing, the 5 elements of a waiver of liability are going to be, the first is, what are the activities that we're doing and how are we doing them? So the activities could be massage, it could be yoga massage, it could be Reiki, it could be acupuncture, whatever it is. Are we going to be using certain equipment? Are there going to be oils? Are the oils going to be heated? Are there hot stones? All of these related things should be included here. The second element is, what are the risks of doing this? So the risks are that you may get burned, or we're going to be using a massage table. It is possible that the massage table will fall in the middle. Or if we're doing acupuncture, it is possible that you could suffer this, whatever it is, you write all of these things. And then the third element is, what is the outcome of these risks? So 1 is, what are the activities? 2 is, what are the risks? And then number 3 is, what are the possible outcomes that could happen as a result of me engaging in these activities? So that can be, it could be death, it could be significant change to quality of living, it could be bruising, it could be soreness, it could be migraines, it could be headaches, whatever it is, this is where you want to include that. Once you've told someone what they're doing, what you are doing with them and how you're doing it with them and what equipment you're using, and you've told them what the risks of that activity are, and then you've told them what the outcomes of those risks are, you've been super transparent. You've explained to someone exactly what it is that you're going to be doing, and there's no ambiguity. I wrote a book called the Yoga Law Book, and I'm going to throw a link to the book here in the chat so you can check it out. I have a whole chapter on waivers of liability. And the big thing that I learned when I was preparing and studying and doing all of the research to write this book was that every time a waiver of liability did not apply, it was because it wasn't drafted clearly enough. And whoever was trying to get out of the response, whoever was trying to have the waiver not apply, their argument was almost always the same, where they would say something like, oh, well, this was never clearly explained to me. So in the first 3 steps, activities, risks, outcomes of risks, we've explained everything. There's no ambiguity. The next is that, having told someone all of this, they have to affirm that they are healthy enough to participate. Once they affirm that they're healthy enough to participate, the next step of the waiver is that they have to agree that they are voluntarily participating. And once they agree that you've told me what we're doing, I'm healthy enough to do this, I'm choosing from my own volition to voluntarily participate, then I can agree to release you from any liability of anything that happens to me, so long as what you're doing with me is covered in this document. So that's really the waiver of liability. Those are the 5 points that you really want to make sure that you hit. And I'm sure now we've got some questions, Karen, so I'm happy to answer them.
Okay. So one of the questions that came in is just the frequency of signing this document. Is this something that you would have a new client sign, or does someone need to re-sign it every time they come in for a session?
I'm just putting water in the kettle, Karen.
Yeah, could you hear me though? Do you want me to repeat my question when you're back with your green tea?
The answer to the question is as follows. If you remember, I sort of said that the waiver only needs to be, you only need to revisit a waiver once you change the activities and all of those things.
Okay, great. Thank you.
But just building on that, the way, and this is part of the differences between a professionally drafted waiver and something that you may download. The waiver should explicitly state that, ongoing services, like so long as the activities that we're providing are the same and you're receiving the same services in the same way, you do not have to re-sign the waiver of liability. And that's an example of, that's just an example of putting a term into a document to help protect you, but it leads to the same point of the bigger question is, when do I need to change it? And you need to change it when something that you're doing changes. For example, when you go to a gym, the classes are the same, the equipment's the same. That's why in a membership, you can just sign up and you don't really have to re-sign the membership, a waiver to work out at a gym, because everything's fixed and they know exactly what they're doing. So I hope that answers the question.
Yeah, so if a massage therapist hypothetically received training and certification in a new massage modality, they would then update the doc and send it out to all their clientele, or wait until people come in and just make sure they know that there's this new thing happening during sessions.
Let's say I never offered acupuncture and now I'm starting to offer acupuncture. That would be an example of a time that you would, for anyone who you're offering it to, you would want to say, you'd want to send them a new copy of the waiver and just be like, hey, we're offering new services that you're going to be partaking in. As such, we've revised our waiver of liability. Please sign and we'll be excited to offer these services to you.
Okay, so we had another question come in from Sarah asking if you know the prevalence of massage therapists getting sued in general, like how often it happens.
I don't have that answer, but this is what I can tell you. And this is why there's not that much information out there on the way that the process works is as follows. If there's a complaint against a massage professional, the only way that the public would find out is if that particular instance went to court, was in the end, there was no settlement. It was decided by a judge. The judgment was publicized, and then we would have access to understand what the ruling was, what the damages were, who won, and all of those things. But again, because in over 90% of all litigation, I think for small businesses and health and professionals, I imagine the number to be much higher than 90%. We don't know because usually it ends with some form of settlement. So one party paying another party $20,000, $30,000, $6,000, $100,000, whatever it is, or insurance getting involved to cover that fee. But there's always a confidentiality clause when there's a settlement. So we only have access to public information, and it's very, very rare that even with COVID has totally slowed the courts in addition to other things. So it's very, very rare that you get a judgment that the public would have access to a judgment of that nature, if that makes sense.
Yeah. So there's another question that you touched on this topic that I think is really important to ask, which is, can massage therapists require that clients be vaccinated? And can they even ask if clients have been vaccinated against COVID-19?
Yeah, this is really important. And And the answer is yes. You definitely, you can ask at Conscious Counsel. The way that we've tackled it is as follows. We put provisions into our agreements, and it's sort of a segue to service agreements, but I want to answer the question head on first. So first question is, are you allowed to only work with vaccinated clients? The answer is yes. The reason why it's not, and originally when it started happening, I thought that it was, and like everyone was getting into the ethical questions of vaccination. I was like, well, maybe it's discriminatory if you're going to say to someone that you're not working with them unless they're vaccinated. But what we've seen happening is that the public policy for the promotion of health is more important than anything else. So the real determining factor here is if you're making this decision because you are deciding that either you're at risk or other people who you work with are going to be at risk, then you are permitted to require someone to be vaccinated. And so our firm had a blog post that we didn't put up, but it was going to be called "No Shirt, No Shoes, No Shot, No Service." Because sort of the equivalent of how I just explained to my clients about the vaccination issue is like, it's the same as someone trying to go to a restaurant without shoes and without shirts. So firstly, hands up if you've ever tried getting into a restaurant without shoes or without a shirt, and write in the chat if you have. And I'm going to say, yes, I have tried that before. Okay, Karen has not. Cool, but it's just like, it's in the same way how a restaurant could be like, sorry, you're violating health regulations if you're not wearing shoes or a shirt. The same way you can say, hey, there's a real danger or health risk that's posed by you not being vaccinated. So it's not mandatory, but all massage therapists have a choice of whether or not they want to work with someone who's vaccinated. The only the small caveat to that is if someone has not had reasonable access to getting a vaccination, then that changes things. But that's I haven't seen that come up. So then the next question is, okay, cool. We know massage professionals are able to ask for proof of vaccination. We know that massage professionals are able to dictate that they will only work with people who are vaccinated. What is a practical step to ensuring that? You totally can ask people if they've been vaccinated. The one thing that you just want to be careful about is not keeping records of it, right? Because you just, my understanding is that HIPAA is not triggered by asking someone if they have been vaccinated, but you just want to be really careful about storing or keeping personal information about people who are about their health, whether it's vaccinations or something else related. So what we've done at Conscious Counsel is for the clients who have requested it in a service agreement, we've put a provision that's called vaccination affirmation provision, which basically is someone saying, hey, I affirm that in exchange for me participating in services with you, that I am fully vaccinated, or I've passed the point of, I'm not even going to use that word, inoculation. I think that's right, but I'm not great with the medical terms. But basically, putting an agreement. That's why we write legal agreements for that are written for a 7-year-old, because that's sort of my level to some degree. But we put in something that says, hey, I hereby affirm that I have been vaccinated fully, and that I'm fully vaccinated, and that in the event that I am making a misrepresentation, or I am, in the event that what I'm saying is not true, I will be solely responsible for all of the damages that may occur from that. And that's an example of getting someone to make a legal promise that's covering your butt without you having to, check personal information and store personal information from everyone, where they're basically saying, hey, yeah, I have been vaccinated, and in the event that I'm lying, and hopefully I'm not, but in the event that I'm lying, this is what the following procedure will be that I'll be responsible for. So Karen, I hope that answers the question.
Well, let me just ask you, would it be okay to just ask to see somebody's vaccine card? I mean, when we get the 2 doses, we get little passports.
Yeah, you can ask to see it, and I don't have a problem. I don't have a problem with that. It just, there's the possibility that you're tripping up on some legal things when you do that. And like, this is what I'll say about everything in law, everything always in law is about management of relationships. So if you've got a good, and the only issue that really would come up is that someone would file a complaint against you based on your behavior. So that's why, like, even legal documents are awesome because they help you if you get into trouble. But the first thing I always say is, like, have great relationships with the people who you work with, and that really minimizes the risk of you running into an issue. So the non-legal answer is, yeah, like, you can totally ask to see someone's passport and then make, just make a check mark on a spreadsheet or however it is that you do things, but just make sure that they're cool with that and that they don't have a problem with you asking for that. And that just be aware that if someone wants to, kick up dirt and start something, you want to be as protected as possible.
Okay. So did you want to talk more about service agreements, and will we be able to touch on trademark during this webinar too?
We totally will. We've got, I see that we've got 20 minutes, so I can chat about both for sure. Okay, so service agreements, as I mentioned, service agreements are the agreements that you have with your clients. So the real purpose, like the actual practical purpose of the service agreement, in addition to, protecting you from refunds and from cancellations and deposits. And I'm going to share a really good example that I did recently with one of my massage clients. But the real purpose is just like to let people know exactly what sort of relationship they're going to have in working with you. And the reason why that's so important now more than it was before is because we need to be, the flexibility that's required for us as massage professionals is so much higher than it was before. It's like, oh, this is changing and this is changing, and now I can only do this, but now I only want to do this. And if I'm too busy, this, and I'm not comfortable with this. And like, the one thing I want to say is, like, it's always all good in the sense that you can determine the terms of what sort of relationship that you want. And I think you deserve that. That's what I've seen a lot of my clients going through, where they want to be empowered by coming up with the types of working relationships that they want, that they're comfortable with. And so what you're saying to someone, basically, from a very high level perspective, is like, cool, you want to be using my services. This is exactly how our relationship is going to go and what is going to happen. And the reason why you do that is that in the event there's a misunderstanding or a miscommunication, or you're feeling vulnerable, or you're not feeling safe, or someone is acting outside of the expectations that you agreed upon, it's really easy for you to just put the document in front of them and send them an email and say, hey, we agreed that if you wanted to cancel it, you had to give 48 hours notice. In this instance, you only gave 24 hours. As such, it will be deemed that the services were provided. If you can make it in for the scheduled time, that's great. I'll be happy to provide the services. And like, there's zero ambiguity around that. And usually with massage professionals, where we meet them on their journey is that they're just getting to the point of really professionalizing their service, and going from the point of like, oh, before COVID, I was just always sort of doing things on a handshake or in this particular way. But now, as a result of everything that's happened, I really want to formalize my working relationships to make sure that I'm protected and that I feel confident and secure with them. So other things that will be involved in a service agreement, and here's just an example. We had one of our clients who was having a really big problem just with no-shows. Not even like cancellation periods, but just people saying that they were going to come and then just not showing up, and then, making a big fuss about it, or whatever else was happening. And so what I said to the client was like, why don't we just put in a deposit where, in order for someone to make a reservation with you through your online software, they have to make a $50 deposit. And that deposit will go towards the session in the event that they do show up. But in the event that they don't cancel properly, or they just don't show up at all, you get to keep those $50. And like, practically speaking, how all of this unfolds is like, even if the person wants to dispute the claim, and they would go to their credit card company and say, hey, my massage therapist kept $50 for me when they never actually provide the services, then the credit card company or Stripe or whatever third party payer is going to be, they would say, okay, well, you have a, massage professional or, a studio has an opportunity to, refute and look back. So then all you would have to do is include a copy of the agreement and say, hey, we agreed that 48-hour notice would need to be provided. This is a email confirmation of when it was booked. This is, the date the client never showed up. This is our follow-up email to them. This is what the agreement stated. And then there's no question about it. So that's an example of like how legal agreements can really empower massage professionals to protect them, protect your time, protect your professionalism, and make sure that people aren't taking advantage of you, and that you have a legal structure, a practical legal structure in place in order to safeguard issues that you've experienced. Karen, I see you popped up, so there's probably a question.
Yeah, well, I felt like you were winding down on the service agreements, which seem extremely straightforward and just a smart thing to do for any business professional. But we've had a question come in a couple different times, so I wanted to be sure that we could circle back to it. And you can let us know if this would be a waiver of liability thing. So the question is, with the information about vaccines being unclear, many people are not comfortable getting them, including massage therapists. So would the massage therapist just include that on the waiver of liability? Just state, I'm not vaccinated, or wait until the client asks, or how should they approach that?
Yeah, they would. And firstly, that's awesome. And I've drafted all in the past, since vaccines have sort of come into the mainstream, I've drafted all sorts of agreements that are on the entire spectrum of some clients who are like, I want to explicitly state that I'm not vaccinated and I will not get vaccinated. And then I have other clients who are like, I'm vaccinated. I will only work with people who are vaccinated. By the way, did I use the word inoculation correctly, Karen? Do you know?
Inoculation?
Inoculation. It's like a mix between inauguration and incubation.
What, when else would we ever have reason to use that word except in the last 16 months? So, it's a new word.
I feel better about myself.
Good.
But to answer the question is, yeah, you definitely, if you're not receiving the vaccine and you never plan on it, you can let people know that. And like, it's not illegal to offer massage services and not be vaccinated. Again, maybe in your jurisdiction, there may be differentiation on how what protocols you have to follow if you're not vaccinated, i.e. you have to wear a mask. Or maybe that's not even part of it, but remember the first thing I said was follow the rules. And then secondly, to me, it makes sense to let people know. Obviously, we started drafting all of these waivers of liabilities before there were vaccinations, and I will say that obviously we're getting through this, and how cool is that? Because I remember doing these when there was no talk of vaccines, because there wasn't. And I think, I don't have a stance if vaccines are good or bad, but it just seems like normalcy is returning. But that being said, to me, it would make sense if you're comfortable including in your agreement to say, hey, hi, I'm Corey, I do massage services. I will never be vaccinated for COVID. And just so in our waiver of liability, these are the risks of working in a COVID environment with unvaccinated people, and that's that. And then again, let's say someone does contract COVID as a result, God forbid, right? God forbid, but then at least you can show hey, well, I told you exactly what we were doing before we did it. And you still voluntarily chose to accept those risks of working with me and not hold me responsible for it. And that's what I want from everyone who's listening.
Okay. And then we have another question that came in from Michelle, wondering why you said an intake is not a legally binding document.
Yeah, legally binding, an agreement at law, the basis of contract law is offer acceptance consideration, which means one person is offering something to another person, the other person is accepting it, and something is exchanged between the parties as a result of the offer and the acceptance. So I'm going to be doing massage for you. You're going to be paying me $85. And so I've made my offer of $85. the consideration is there, the offer is there, the acceptance is there. That's and it doesn't always have to be signed, because you can have oral agreements and there's different ways that you can piece things together. But from what I've seen from the intake forms that I've worked with massage professionals, it doesn't meet that requirement of offer acceptance consideration. It's not a legally binding agreement. It's supplemental information that may be required by insurance. It may be required by a regulatory body if your jurisdiction has massages being a regulated industry. But at law, that's not a contract. The contract is offer acceptance consideration.
Okay, so I'm going to jump in with a little public service announcement and let everyone know that they'll receive a link to a recording of this webinar. So if anybody wants to go back, and listen to anything that Corey said so far, you'll be able to do that. Do you want to move on? We have about 10 minutes left. Do you want to move on to Trademark, especially as people have been doing things online and creating courses? Like, how do people protect their
Trademarks is like my favorite thing to talk about. Before I do that, I'm just gonna let Jake know. So everyone who's listening, firstly, I'm gonna read through the chat comments to see if anyone tried going into a restaurant without shoes. And I'm curious to see that. I actually will read through what the snacks people have been eating are. But Jake's gonna post something in the chat right now. So if based on everything that I've shared, it sounds like you'd like to get legal agreements in place, or you want to work on getting a legal game plan and having Conscious Counsel execute that for you, you can book a free consultation call with me. I'm happy to chat with you to understand a little bit more about what it is that you're up to, and sort of come up with a game plan or a proposal of what it would look like to work with us. So I do that just so everyone knows it's not legal advice. I won't be able to review any documents that you're currently using, but I'll always offer that, because at a minimum, I try to make myself accessible so that, if someone just, is like, hey, I don't know what I don't know, can you point me in the right direction? I'm happy to do that. And also when we have clients who are serious about being at best legal practices and minimizing their exposure to risk and wanting to protect their branding, like I'm going to talk about for Trademarks in a second, it's a really cool opportunity for us to have a quick chat and for me to explain a little bit about what we do at Conscious Counsel and how we do it. So that being said, I'm going to wrap up here with a chat on trademarks. And trademarks are like, they're the sleeping, they're not I guess they're like the sleeping giant, or I don't know, there'd be that sleeping thing that it's not, is it necessary to get a trademark for your business? And the answer is totally like, it depends, but most likely yes. And if it's something that you're in a position where you're investing in your business, it's a really important investment to make. So I just want to explain a little bit about what trademarks are, and why it's really important to have them. So a trademark is a registration that you make with the federal government that basically it's registering either a word or a series of words or a logo. And what you're doing is you're letting the government know, who's going to let the whole world know, that anytime anyone sees this word or these series of words or this logo, which are being used to provide massage services or massage education, whatever it is, those goods and services being provided will be linked to my business. And so what you're doing, the purpose of it is to let everyone know, like, hey, when you see this, you know that it's being provided by me and my business. Now that's the theoretical use of a trademark. The benefits of registering a trademark is like, let's say you're either building a business or you're about to start a business or you've been in business for a while. One of the things that comes part and parcel with a trademark is exclusive use. So what that means is the moment that I register my trademark, I'm the only one who is allowed to use that word or those series of words or that logo in association with the goods and services that I offer. And exclusive use is really important because it means that you don't have to worry about someone copying you. So the three things that I want to talk about with trademarks, one is exclusive use. This means I'm the only one who's allowed to use it. And that if anybody, loves my name or thinks what I'm doing is really cool and then wants to copy me and go off and do it on their own, I have the rights to be the exclusive one using that. The second benefit of registering a trademark are enforceable rights. And this is like sort of tied to exclusive use in the sense that the exclusive rights that you have, the enforceable rights that you have from registering a trademark is like, because the trademark is formalized and registered, that at law, that gives you a whole suite of actions that you can take in the event that someone's copying you or using something that you're, that you've created or whatever it is, whether it's an online course or something like that. But if you don't register the trademark, it's very, very difficult to access those rights in the same way. So let's say I make an online course about massage called Massage Drinking Green Tea. What an awesome idea. Okay. And now it takes off and people love it. And someone says, whoa, I want to, do a teacher training for massage for people drinking green tea in my jurisdiction. And I want to share, the online course plus do all these things. Because you register a trademark, you can license out that trademark and you can let someone else use it under particular rules. But if you don't assert those rights, and it's sort of like professionalizing or leveling up, like if you don't register, you don't have access to those rights. And then the third reason, and this is like more of a reactive part, and this is not fun, and I've been through this with clients, and I'm currently going through it with one right now. As I've mentioned, the benefit of trademark is exclusive use. But what that also means is that if you do not trademark, it is possible that someone else can register a trademark that even if you've been using it longer, if they go and register it, they're automatically in a better position than you are. And then you have to fight to assert your rights and get back to that. So what's been happening with one of my clients now is she's been in business for 20 years. She's got a really, really cool name that she uses, and she never trademarked. Someone else actually trademarked it. And now that person sent her a cease and desist letter saying, hey, really, I see that you have this name. We formalized our trademark registration 2 years ago. Therefore, you have to change your business name. And at that point, it doesn't matter that she's been using it longer because it's always a race to the registry. Maybe I'll sponsor a 10K race and we'll call it Race to the Registry. But it's always a race to the registry of who registers their trademark first. So if you fall asleep at the wheel and you're like, oh yeah, I will trademark, I'm going to do that in the future. And in the interim, someone else does register that trademark and it gets completed, it'll be very, very difficult to keep your brand no matter how long you've spent building it up. So that's basically the 411 on trademarks.
So we had a question come in about trademarks, which is how is trademarking a name different from registering your business name, like with your county or city?
Yeah, so what registering a business name means is that business entity, at law, there's something that's called privity of contract, which means that whoever is entering into an agreement, it will be bound by it. So when you register a business name, that's letting the government know, like, hey, this company name, right? Conscious Counsel LLC, which doesn't exist, but if it did, this is a legal entity and it can open a bank account and it can pay taxes on its own and it can enter into legal agreements on its own. But the difference between it, but that doesn't give you, it doesn't give you exclusive use. What it does is it allows you to have a bank account, to sign contracts, to hold yourself out in that particular way. And no one will ever be able to take that away from you. But when you register a trademark, you get all of the benefits that I mentioned of exclusive use and enforceable rights and preventing someone else from being able to register that mark against you. But like, let's say all I do is register Conscious Counsel LLC, and then someone else goes and registers Conscious Counsel, operation as a law firm, all of these things. They can never take away my ability to be called as a business Conscious Counsel LLC, but they can send me a cease and desist letter about the engagement in the activities that I'm doing. I hope that distinction makes sense. It's like, I'll always be able to have a bank account with my business name and I'll always be able to sign contracts as my business name. But if there's particular goods and services that I'm doing that has a similar name, then the trademark will prevail. And like just the logic behind that is, okay, then what I could do is I could come up with a company called Nike LLC, and then I could just hold myself out as Nike, and Nike wouldn't be able to do anything about that, which obviously isn't the case.
Okay. There's one last question I'd love to ask you. It would be boomeranging back to the service agreements, but I think it's important.
Yeah.
Which just is, does the service agreement need to also include the price per session?
Yeah, it definitely can and should. So remember, the service agreement is the relationship that you have with your clients. So that's where if they're buying 10 packs, that's where you can put the price. If it's one session, that's where you can put the price. In a conscious counsel, we always draft a schedule that describes specifically, okay, this is the cost of each thing. And if you buy at this price, this is how it varies. But the answer is yes. And so I'm going to wrap up because we're at time, but everyone, if you had fun and you enjoyed this, just go into the chat and type the word fun, because I love this. It's always a pleasure for me. Wow, great fun. My gosh. I'm happy. I'm happy. So lovely to meet everyone. Karen, thanks for the opportunity to share information. I hope that it's helpful. And lovely to see you again as always too.
Thanks. Hey, it was great. Thank you so much. Appreciate it.
Bye, guys.
Thank you, everyone.
Ciao. Have fun.
Okay, bye-bye.